Uh, all right, there we are. It's recording. So officially welcome to the Ask Me Anything Live. What is our date today? October 10. So this is for anybody watching the replay, but we'll see if other folks here roll in. Cindy, good to see you. How the heck are
Oh
you?
my God. I know we need to catch up. We really
Totally.
do. But I know I'm having withdrawal symptoms. We used to
Right? I
talk like
know.
every week, every 2 weeks.
Yeah,
I know.
I get
You
it.
good?
What was that?
You good?
Yeah, overall, so kids are, I joke, they're relatively back in school. My daughter's
Why?
5. I'm just joking because she's 5 and we quarantined like so many people. So it's like the little ones, their immune systems are catching up, right? She didn't get like all the colds she would have got between like ages 3 and 4. And so she's getting
Yeah.
everything. And so she
I have
has
to tell
sick.
you though, it's not just the little ones. My son is 7. He just turned 18 actually, and he's homesick too. Like he's been
Mm.
sick all year.
Oh, it's such a bummer.
It's constant. I don't know
Oh, I'm
what's going
so
on.
sorry. I know.
I don't know either.
Catching up
So
with everybody, I guess. Well, yeah, so it just has meant like I've had little ones home off and on, and school started late for us. Like we start after Labor Day here in Seattle, and then our teachers were on strike. So we actually didn't start until mid-September.
oh my God.
Yeah, so my fall schedule, I feel like I've had like
Oh
5 work
wow.
days total this fall. So, anyways, it's good to be
Mm.
here. It's good to see everybody. I would love to support you if you've got any questions or anything you want to talk about today related to the intersection of law and business. Um,
So
anybody?
I,
Anybody?
excuse me, I have a question. I just recently updated my terms and conditions on my website and policies and disclaimers. So there's a section in there that this website is not for anybody under 18.
Mhm.
However, I'm a little unique and a little different in that I run a child placement agency. And so
Mhm.
anybody who's pregnant and is under the age of 18 is really, they're independent. They're able to make a decision about whether to place their child for adoption. So the website could actually be
You for
used by someone
somebody.
under 18. And I don't know quite how to write that into the terms and conditions.
Got it. Okay. So yeah, so the way and you so you must be referencing my website protection package, is that right, Stephanie? Yeah. So typically if you are going to have a website that collects information from somebody under the age of 18, right? You have to have either parental consent or guardian consent, right? Somebody who basically has legal authority to do that. But what it sounds like you're saying is that, and I don't know if this is a state law or a federal law, that if you are under the age of 18 and placing a baby up for adoption,
Mhm.
you're saying that people have
Correct.
legal authority
It's
to do
not just
that.
a state. It is a state, but it's applicable in all states. So
Got it. Yeah, yeah.
they're basically emancipated for the
For the
lack of a better
purposes.
term for
Yeah.
the pregnancy.
Got it. Okay. So you could just have a section that says, right following that statement, if you are under the age of 18 and placing a baby up for adoption, right?
Mhm.
This website is available for your use as well.
Okay.
The trick with collecting information from minors is that there are rules that apply about what you can do with that information, who you can share it with, who you can market to, right? So long as you're not selling your data, sharing that data, doing anything with it, the rest of the terms would apply, including the privacy policy, right? Where
Mhm.
only in the event of, let's say, a business transfer or liquidation event or
Mhm.
some other, regulatory event that requires you disclose that information from inside your business, right? You're not going to be willingly sharing it. And I assume, like, when you do your marketing practices, are you doing some of the regular channels like advertising on Facebook or posting ads on the social media sites? Are you doing some of that?
Not yet. We're getting ready to go into Facebook ads. Right now we just do Google ads.
Okay. Because you may, depending on how you create your ad audiences, right, you may need to be removing information that belongs to those individuals that are younger than age 18 if they're providing you that information, right? So for example, if somebody is under the age of 18 and let's say that they opt into your site or they reach out and contact you, what I'd want to make sure of is that you're not utilizing their information to like retarget them online or target other lookalike audiences.
Yeah.
Unless, you know what I mean?
Mhm.
Because that just might mean more regulatory oversight, or that you'd need to have somebody, you need to have an attorney specifically review that scenario when it comes to retargeting.
Okay. All
Okay.
right, great. I'll keep that in mind. Thank you.
Yeah. So just keep in mind that, especially in regards to the disclosure of your privacy practices, you may need to make some updates or change the way that you do your advertising practices when it comes to that point.
Okay. Perfect.
Okay.
Thank you.
Yeah,
Great.
absolutely. All right, good question. Gina, how are you?
I'm fine, thank you. I have followed you for quite a while, and somebody had referred you about doing trademark stuff.
Oh, yeah.
And talk to me about when one should look at a trademark, when they shouldn't, how you can do it in its trademark. So I have a podcast with a partner, and then I have my stuff and my name, my business name I did when I first started, Great Vibes, and Great Vibes Transformations. But I figured out real quickly to add, and so I added to my LLC, doing business as Gina Rock Coach. So can you just talk in general about the trademarks, because you've been referred as the person to go to?
Yeah, totally. Great question. So trademarks, typically where I start with somebody, especially in response to your question around, am I ready, or when does somebody know they're ready for a trademark or need one? If you've created, because trademarks apply to, when I do my analogy of your brand or your business, right? And think of seeing a mountain in the distance and the snow-capped peaks at the top of that mountain, right? That's what people view and what is accessible from the marketplace from a brand perspective, right? The snow-capped peaks, the top of that mountain. That's what you protect with trademarks. It's going to be a brand name, a business name, a logo, a tagline. It could be a signature course or program or offer name, right? If you were in the like widget world, I just had a guy on the podcast, his episode will come out tomorrow, where he talks about patents, right? If you're creating a patentable item, it might be the name of that item, right? Most of the folks that I support are not into creating, I call them widgets, gidgets, and gadgets. They are more in the information space, right? So, but trademarks will protect a signature name, right? A tagline, a brand name. It's basically a word or phrase. The rest, if you go back to the mountain analogy, the rest of your business, right? The rest of the stuff that you create in your business, workbooks, videos, tutorials, frameworks, right? Like just the way that you discuss your ideas, teach people your methods, whatever it is that you do, that's the body of your work. That's protectable by copyright. So trademarks, just think of trademarks as kind of the top of the mountain, the most visible assets from the marketplace. And usually the folks that I work with, you know, most of them need at least one. Some of them need a couple trademarks, depending on what they're doing. If somebody has a really robust business, they might need a handful, right? And so it is an investment because they become a core asset of your business. But most people don't need more really than a couple. And so it's not that big of an investment when you look at it from that perspective. And especially when you think long-term about your business, and particularly, like I just had a consult with a woman who's going to become a client, and she's got a podcast, she's creating a course, right? She's digitizing a lot of what she's done in the consulting world for years and years. And she wants to create assets that she can sell when she's done with the business. She actually wants a sellable business, right? And so trademarks and IP protection become really important, particularly if you're thinking about your exit strategy and what is it that you want to have created inside of your business or done with your business, so that you actually, whether your business is an asset on its own that you sell, or you actually break apart the assets inside of your business and sell them, right? So, you know, you need a trademark. My litmus test for people is I ask them, how would you feel if somebody else took this name in the marketplace in the same area that you work in and used it in their business? Right. And some people, it's like, you know, I've had a couple be like, well, I'm not like overly attached to that particular name, so I guess it's not that big of a deal. And then other people like, oh, I'd be so miffed, right? That would really like rub me the wrong way. And I'm like, okay, if you're in the second category, then you're probably feeling somewhat possessive around that particular asset, and particularly the naming or phrasing of it. Should probably get it protected. And the other thing about trademarks is there is a time element involved, because the application process relates back to first use in commerce. And so if you've been using it in commerce, or you're thinking about using it in commerce, you want to go ahead and use it. And you know, the other question I get is, well, should I file for a trademark registration after I begin using it or before, right? And the answer is, the earlier the better. If you've already been using that asset in commerce, then go ahead and file now. If you haven't yet used it, then the question becomes, you know, obviously, if you're under extraordinary budgetary constraint, maybe you go ahead and launch and you put the TM after it with the intent that within a month or two, you're seeking protection, not like a year or two, right? But like it's next on your list to do. And, you know, alternatively, if somebody's like, well, I know I want this phrase, but I'm actually not ready to launch the course. So I worked with a gal last year, and she was launching a whole program, a challenge, an online website, all around the use of this one phrase, but she was in the building phase, right? So she still had a few months before it was even going to go live into the world. She wanted to make sure nobody else could get in line ahead of her. You can actually file, there's a 1A and a 1B basis to file for trademarks, and one is intent to use and one is actual use, right? So even if you have not yet used the phrase, but you've done all the proper searches, you know it's available, then you can actually file on an intent to use basis, and it still puts your application in line, assuming nobody else is in the marketplace using that phrase. Right. So, and then once your application is in line, that really kicks off the process where the USPTO, first you get assigned to an examiner. Right now, the USPTO is a little bogged down. That process in and of itself can take a few months. It's taking even just a while to get an assignment to an examiner. Once your examiner is assigned, though, your application will be listed in the USPTO database, and you'll be listed as the applicant, right? Once you get it, you have to go all the way through the process. It's a 12 to 18-month process, and that's what I take my clients through, right? So I would manage their application through that process. Then you get your application converts to registrant. And that's when you know somebody actually holds the registered version of that mark, as they become the registrant, no longer the applicant. And there's a 30-day window of time where once it's published for notice, once your application is published for notice before it registers, that somebody in the marketplace could show up and decide to basically like fight you on that, or say, no, I actually used it first, and show their first use in commerce. So you do have a window once it's published for registration, where somebody could show up and, you know, file something that that would stall the progress, or you'd have to respond to. But for most of my clients, that doesn't happen. You know, if we've done the footwork right, we've done the groundwork, and I always start the process off with what's called a knockout search, where I have a team member who's a specialist in trademarks, and she runs all of the preliminary searches for me. She's going to search the marketplace. She's going to search the USPTO, because it's not just about searching the exact version of the words or the phrase that you want. It's about searching any word that's similar or variation of that word, combination of words. And so it's a little bit more complex than people think it is. And we do that to make sure we don't find anything that would automatically preclude your application from success, right? So we kick off every trademark client with that knockout search first, and assuming it passes that initial test, then we proceed with actually preparing a draft of the application, reviewing your questionnaire, because I do all of my initial trademark intake with a detailed questionnaire, so I can collect as much information as possible about your use of the mark, your awareness of the marketplace, etc., before we even prepare the application. Yeah, that's, I mean, and the quick overview, again, the timeline is by the time we file, put you in line, but it'll be a 12 to 18 month process. The cost, so my cost for a single mark, right? Because you can only do one mark at a time, but single class registration is $14.97. There are some clients where, let's pretend they've got a podcast, they've got a consulting business where they consult with other businesses. They also coach individuals and individualized programs, you know, like a variety of things going on where they might need a couple classes or even 3 or 4 classes. It's rare, but it does happen. And so in that instance, my fee bumps up a little bit because I have to research each class and come up with a draft set of language for your use and your description within that class. And then we do that across each of the classes, right? So it's just more work. It's actually like preparing a whole separate application, but that bumps up $250 per class for my work. And then also there is a $250 filing fee at the USPTO level per class. So what that typically looks like is that the investment for my clients ends up being between like $1,750 and, you know, $2,500. That's typically the range. So yeah, that's kind of a quick overview of the logistics, but where people often get hung up in the process is even that just initial description of their use within the class, selecting the right class, because the whole trademark system, the USPTO system, is actually designed to protect consumers. And the way they do that is around this class or category type of listing. And so it's possible that somebody else could use the exact phrase or name that you're going after, but in a totally different category related to separate services or separate goods, right? But it can be confusing for people when they're initially trying to do the research and sort out, is the name even available? How do I describe this appropriately within the class? And then the other thing that will often trip people up is getting what's called an adequate specimen. So when you submit the application, you also have to submit a specimen or specimens showing your actual use in commerce. And some people think, well, it's been on my website this way for years, so this is fine, and I'm just going to submit a screenshot of this. But if it doesn't actually support the application and the description of your use in that class, like most people, 90 to 95% of my clients need help actually fixing their website so that they have an adequate specimen. And repeatedly, I've had people come to me that are like, hey, I filed my own application and now I'm having all these issues and I don't understand what the USPTO is asking of me. And can you take a look at it? And I'm like, oh, it's too late. Like they already responded and then the USPTO got back to them and they basically have a final chance, but they can't change their specimen at that point. And so it tends to be a complex process, even though from the outside, some people think like, oh, I got this, it's fine. And they can get stalled. Like I have a good friend who's plenty smart guy. He just wasted a year of his time fighting the USPTO, trying to go through this process on his own, submitted the filing fees and the money to get everything going, and then was denied. Did not ever get a finalized registration. It was a super frustrating process for him. And it was just over a really simple mistake at the beginning. So that's just a little heads up because that part of the process can be super aggravating for people.
I wanted to share with you why I asked the question is because, and I'm in the energy healing type world of human design. And human design is vast now. There's lots of different things, and some of them have trademarked and some have not. And vocabulary is becoming more and more important. And I use my own vocabulary. And, when you start doing the promotions on it and you use your own vocabulary, then it gets stolen, so to speak. And then it's like, what if they trademark it and then I'm not allowed to use it and it was mine originally? So that was where the thought came from. As this world has expanded, and I am very much of my own vocabulary, and I don't need to use their vocabulary. And my clients have not had good, they had readings with other people, but when they were reading with me, I've never had a single client say anything other than, oh my God, you just explained everything I needed to understand about everything. And so it was a totally different experience for them. So recognizing that, I recognized I could have a challenge. And then as I've been thinking about this, and I've approached it a couple of times to think about it, and I haven't done a lot of social media because of this. Do you know who Denise Thomas Duffield is in Australia? She wrote a book called Chillpreneur. Get rich, lucky bitch. Money mindsets.
Yep, I've
she
heard.
was rewriting her book, Chillpreneur, and somebody had trademarked the name Chillpreneur. And she hadn't caught it. And so when she rewrote the book, she did Chill and Prosper. And it is a really good, it is a complete overhaul of the book. But she had a published book with Hay House with the name Chillpreneur, and somebody trademarked Chillpreneur. And the book just came out recently, and it was very much of a, oh, wow, this is obvious. This is her word. I mean, anybody in the industry here that we work with would have put her name to it. She's got huge followers. So she's never complained. She's never whined. All she said was, I go with the flow, and we have a new name called Chill and Prosper. And to be honest with you, it's worth reading, because when I wrote the original, it was blah, blah, blah. And now we've gone through all these other things, and it's a whole different, and it is a whole different book. It is. However, she would have just called it, the second edition, and she probably made more money off of it doing the other way. But it really hit me that that's her word. It was just her word to be able to do. So talk about copyright. What do we do to ensure we're copyrighted? And is there something that you have, like as a package, that we can purchase where we can ensure we have our copyright stuff done correctly? Or
so
I haven't looked at your site on copyright until you said that. I have literally been like thinking I'm going to send you an email about my question and let you do one of your things and say it and then watch it back. And I happen to be on where I didn't have a session right now.
Oh, good.
And I had an opening, and you sent your email as a reminder, and I'm like, oh my gosh, I can ask my question live. Excellent. So now that you've asked it, you triggered the next question is, what do you have for those of us who probably ought to be doing some copyright stuff right now?
Yeah, absolutely. So the quick response, so I want to respond to what happened to Denise, is that if you are a person like that who has developed your own name for things, maybe you even created a new word. I know some folks in various industries who have done that. Those are the kinds of things that can kind of catch on and garner a lot of attention, and they are proprietary. And so you should absolutely be first. There was actually another gentleman who I was introduced to who is also Australian based, and he has a business that a lot of people know about, took off like wildfire. Somebody in the UK trademarked his business name in the UK, even though that's one of his big areas, right? And that's the other thing about trademarks. If you have a big international following, you need to be aware of where else aside from your home country you may need to be looking at protecting that mark, right? So it ends up that I end up helping a lot of foreign entrepreneurs, right, based outside of the US, who have a big portion of their audience in the US. It's called reaching in, right? They're reaching into the US marketplace, obtain trademark registrations here as well. But it's super important. And for my clients are Canada and Australia and US. And I have more in Canada than I have anywhere else. Oh, wow. So Canada's my large, and I'm in Texas, but Canada, and I would say Australia's next. I have, you get one or two clients and they love you and they
share the love and
Totally.
you do the thing, and all of a sudden it's like,
Yeah.
I do sessions just for Australia. I do live things just for Australia's timeline. Literally, because I have enough people there.
Yeah, no, that's amazing and very common for folks in the online information space. So what I just for quick feedback, when you are in a scenario looking at potentially getting international marks registered as well, what typically some advice that you will probably hear in the marketplace is to register, for example, in the US first, right? Get that registration underway, because what happens, foreign offices will often look at, do you have a registration in your home country?
Oh,
right?
okay.
And if you do, or if one is pending, you can actually be given priority for a registration in some other countries. And so like if Canada is your second or is your biggest audience, right?
It is my biggest
I'd still start with US, register here, and then immediately file as well for registration in Canada. I just went through this with another client who actually got into a battle with he did not realize that he needed to research the US market. He's actually Canadian based, needed to research the US market before using his mark in advertising on like Facebook and online audiences, right? But capturing a lot of people from the US marketplace. And there was a mark already registered under the same name. And so, of course, they got into a battle. I ended up helping him just buy out both of the marks owned by the US based company. So he now has exclusive use over that phrase in the US. And as soon as we got that, I helped him file by connecting him with counsel that I work with for clients that are either US based or Canadian based and need Canadian registration. So that would be the order of priority, like US first and then file for Canada so that you get protection there as well. Copyrights, you don't have to do that. You don't have to do cross-border registrations for copyrights. Copyrights are a little different. There's something called the Berne Convention, where if you get copyright protection in your home country, I think something like 164 countries have signed on to the Berne Convention. You will automatically be given recognition of that copyright in any of those countries that are members of the Berne Convention. And so with copyrights, the key is, and here in the States, right, because there's also a lot of confusion around like, what is a copyright? And do I have copyrights just by creating the work, or do I actually need to get a registration? The answer is yes, you have copyright, which means the rights to whatever you've just created, the moment that it takes tangible form, right? So our Copyright Office does not protect ideas. It protects your unique expression of that idea, right? So let's pretend that you know, the various ways that people tend to put ideas down into tangible form, at least in the space that I work in, are written form, right? They write an article, or they create a worksheet or a workbook, or they write a real book, or they self-publish or whatever, right? Or they create a podcast, or they write a series of articles, or they, you know, publish content to their website. Maybe they create video content or a series of video training, right? So these are all ways that that this content takes tangible form. These ideas take tangible form. And the question then becomes, what do you protect, right? And Gina, just because I don't have great, my sound equipment today, I had to send my son with my headphones. I'm getting some feedback, but I think it's coming through your machine because you're not muted. Just for purposes of the recording, yeah, just mute for a second, and that way people listening to the recording don't get that feedback. So the question then becomes, for most of my clients who honestly create quite a bit of content, right? They're creating content all the time. Most of them is like, okay, well then what do I protect? And I really help people focus on their core assets. What are your core assets that if you look at your business systems, you look at the way that you interact with your clients, because I think we all have ways that we are, oh, here, let me admit Diana. we all have ways that we are repeating the same information over. Cindy, good to see you. I see that you have to run. Did
Yeah,
you
I popped a question in there, so I'll listen to the recording when it.
Oh, okay,
Yeah.
perfect.
Okay.
Okay,
Thanks.
awesome.
Okay.
Bye, Cindy.
Bye.
When it comes to, and welcome to Diana, when it comes to the copyright protection, because you can end up copywriting a lot, like getting a copyright registration for a lot of things, right? So the most overwhelming part of the process for most people is actually deciding, what do I protect, right? Because they're looking at everything that they've created over time and trying to sort out, like, what of this is a valuable asset worth protecting? So look at your core assets. You might already know what those are. Maybe you don't. Maybe they're yet to be created. That happens for some people where they're like, well, my stuff is really all over the place. I don't know if I have kind of a streamlined system where I've really expressed the core of my ideas in one place. Because you want to look at, first of all, what format is the best expression of that idea? Right? So for some people, video might be better. Video training might be their very best expression of an idea. For others, it could be an infographic. For others, it could be a podcast episode where they talk about a certain thing, right? For others, it could be that they've already compiled a workbook that accompanies their course, and it has everything in there that they really consider the core part of their teachings. And so it's really taking inventory of what, and let me actually, speaking of that, if you are on this call, I will just share this for free. This is a resource that I create for my clients, but it would help anybody that is wanting to take inventory of their core assets and understand what they should be tracking about those assets. Give me just a second and I will grab the link and pop it into chat. Okay, so here it's a Google sheet that I created. Let me just grab the link from that. You need to make a copy first before you can use it, right? So it will say copy before use. Let me just go to everyone. I'm just popping that link into the chat. You can grab that and it becomes a really powerful way to track what is your IP inventory? What are the assets that you're creating? Whether it's articles that live online, whether it's a single long form blog post that has a whole bunch of your key ideas in there, whether it's a video series that lives on YouTube inside one of your courses or whatever. But the important thing is that you track those assets. You understand, do you have exclusive ownership over those assets? I had a scenario that could have gone really badly wrong recently where a client reached out and said, hey, Heather, I need you to reach out to this list of people. They've taken my assets online. They've taken some content off of my site and are selling it and using it in their online business, right? And so I'm really glad that it went slowly enough because I pinged him back with some questions. I asked him where they had been tracking this stuff. Where does the content live? I asked him enough questions that by the time he really thought about it, he realized clear back early in one of the early phases of building his business, he'd actually hired somebody to create some of that content for him. And although it was created for his business, she reserved the license to sell it elsewhere as well, which she did. So other businesses, not through faults of their own, it wasn't like they'd shown up and taken it off his website, were using the same content because it was scripts that this woman had created, right? So this is a really important concept for everybody to understand and track in their own business, is if you've had somebody create something for you, one, you need to have an agreement in place that says you own it. You have the ability to own the copyrights or register the copyrights, right? That it's exclusively owned by you. And if not, you should not probably be seeking copyright protection over that work. If somebody's reserved a right in something or you just have a license to use it, it's not yours. And the other key part of this conversation is that for people, because I've also had people show up and say, hey, I'm teaching this class next week. And they hold up, about this book that I really love the concepts in. I was going to walk my students through it. And I'm like, well, did you write the book? Oh, no, I didn't. It's like, no, you can't teach. You can't do this in your business. Offer a course teaching and selling somebody else's IP, essentially, right? So you have to understand that if you are somebody that has done some of that in your business to date, first of all, I invite you to reevaluate where you're at and where you're headed, but looking at all of those pieces of content in your business that you're using, especially if they belong to somebody else. You can't fold those into something that you're going to register with the Copyright Office, right? Unless you have permission to seek ownership over those things. So those are a couple of really important concepts when it comes to obtaining copyright registration. But the other reality is if it is content that you have truly created yourself, like Gina, I heard you say, I really do things differently. I have my own way of expressing these ideas and talking about them, and people just don't hear this elsewhere, right? So and you have 100% certainty that what you're using is not other people's IP, then that's the kind of thing that is appropriate to go seek protection of, right? And truthfully, most people can do the copyright registrations on their own. You're going to go to the Copyright Office. They have a system with directions that you can walk through. For the most part, you're submitting digital specimens, right? So whether it is a web page showing the copy that you're using on that page, or whether it's a video, right? You did a video training on something, right? You're going to submit the digital copy of that video. Speaking of copyright, here's Barbara. Barbara supports people with copyright registrations. So you just want to make sure that you have all of the information you need to be able to submit that application, but it's going to be things like ownership and when was it created and who were the authors, if there are co-authors, that kind of thing. Welcome, Barbara. But that is a process that you and I've had others of my clients go through themselves. The fee for copyrights is much lower than trademarks, right? So, and that's a benefit to people who create a lot of content, because let's pretend that you have, 10 or 15 or maybe even 20, what I call core assets, still is not going to be overly expensive to get all of that registered, right? You're talking about, $45 to $65 versus on the trademark side, a fee to have an attorney prepare the application, walk through the process with you. It's just a more complex process. And then the filing fee separately to the USPTO of $250 per class, right? So it's just, you're talking about the assets at the top of your business, what's visible from the marketplace, versus a whole bunch of content that makes up the body of your work that may be subject to copyright registration. So hopefully that was helpful.
So if you had something and you had a workbook that had a vast majority of the stuff you want to copyrighted, you would just do the workbook. And then if you did videos about it, you would do it as a separate class. For
the copyright, just a separate registration for the for the copyright registration.
And if you talked about it on the podcast, then you would do a separate as well.
Mm-hmm.
It would be really good to actually compile your materials into a really quality workbook. Sounds like.
Right. Yeah.
And update that. Are those updatable, or is that
the workbooks? Yeah,
yes.
totally.
Oh.
And yeah, absolutely. And so if you do make significant changes to a work, so even look at published authors, right? They'll take a book and do like, revised and updated version 2022, and gives them a whole new reason, not only from a marketing perspective, right, but also IP protection perspective, that if they're making some changes and updates to the book, to go seek a new registration over that work. And so, yeah, you absolutely can update things, and should, if your content or messaging evolves or changes, which for a lot of people it does over time, right? So that is important to track that. But also certain things in a series, if they're truly published in a series, can also be protected in a series, right? If it's created within the same calendar year, right? That has to, you can't just like hodgepodge a bunch of things together and call it a series. Truly needs to be like a newsletter series or article series or series of photographs that you published all around a theme or whatever, right? So, but yeah, you can go directly to the Copyright Office website and look at the directions. Sorry, I'm just getting a few messages. Want to make sure that people are getting in.
Does that include other countries? Is it the same like the trademark? Is it, but that trademarks that 160 countries, it's sort of an automatic is what you're saying?
That's copyright, not
Copyright,
trademark.
sorry.
Yeah, trademarks are the one that you have to seek protection in other countries as well. They don't have the same cross-border protection. Yeah.
Well, thank you. No, this has been really, really helpful. And I was really expecting to buy a copyright package from you, at least. So I was sort of like surprised and shocked, but thank you so very much.
Yeah, you're so welcome.
I am going to send some people over on some, even if I'm not quite ready on I don't think I'm ready yet for the trademark, but I know some people who are.
Oh,
that need
awesome.
to stop and do it. So I'll send some referrals.
Yeah. Oh, I appreciate that. You're so welcome. It's great to connect with you. I am going to drop a link into the chat for my IP registrations page. Most of what I do is trademarked. I will coach people around copyrights and do a certain amount of helping them do an overall assessment of their IP. And if you are here, be sure to grab that Google spreadsheet link so that you can begin to track your own IP. But Barbara, you should connect Gina with Barbara if you've got questions, who actually does copyright registrations. So that, you know, she's been through the process numerous times, comes from a background of, you know, academia, and yeah, could be a great resource for you. In regards to the link that I shared regarding the IP registrations page, though, it will have all of the FAQs that I typically get around trademarks. So anybody looking to obtain a trademark registration that has questions around trademarks should definitely check out that page, because there's a whole bunch of questions there that I answer for people right on the page. Yeah, awesome. Thanks, Gina. Welcome, Diana. How are you? Oops, you're talking and I think you're still muted.
I'm trying to unmute. Now I'm unmuted. I'm good. How are you?
Good. Good to see you.
Sorry being late. I had a brain like delay. So here I am. So
no worries. Nope, I get it. I am going to look. My friend Cindy, who had to pop out early, she had a quick question about where to see if a program name is already trademarked, right? And this is a great question for anybody that is about to name anything, whether it's a new business, whether it's a signature service or program or course, whether it's your book title, right? So Gina talking about Denise's example, right? Like Chillpreneur. And the reality, there's Barb's information. Thank you, Barbara. The reality is you cannot use a trademark to protect your book title. This is the other thing to keep in mind around book titles. You cannot use a trademark to protect the name of your book unless it is a series. So if you're publishing 2 or 3 books, like look at like the Harry Potter series, right? Under the same title or phrase, then a trademark can be used to protect those books, but you cannot get trademark protection around a single work. So that is important to keep in mind. And then let's see, what else was I going to mention about, in the early search days, right? So Cindy's question about where do you search? You would search, first of all over Google. I want to say all over God's green earth, but mostly Google. And what you're going to do is search variations on the phrase, right? So you're going to, let's pretend it's 3 or 4 words. You're going to look at the past tense version of the words. You're going to look at the current, like ing, add an ing, like look at variations of the words included in the phrase. or various spellings. Like some people get really creative with spellings, which depending on how that, look, like there's ways that it's done well, there's ways that it's done really poorly. But you want to make sure that you creatively explore even like phonics and the different ways that you could spell that word, because that can be enough to boot you out of the running at the trademark office, as if somebody doesn't have the exact spelling, but something similar that has the same meaning. And you're in the same class or category. So you're going to search Google, right? Obviously, you want to look at domain searches, like looking up domains. That does not do anything in and of itself. Just because somebody owns a domain doesn't mean that they have the rights to the mark at the federal level. And you still have to demonstrate actual use in commerce, right? So there have been times where somebody has like purchased a domain, but they're not actually using it, because you can go find when certain domain names were purchased, right? So you can do a lot of hunting around, or let's pretend, here's an example. Let's pretend you started using the name in 2018 and you go to search for the domain and the domain is taken, it's registered, but the domain was registered in 2020, right? That's after you were already using it in commerce. You can do some unique searches online that will help support your knowledge of who is first in line, right? Given some of those points of data. Not to say that a domain purchase correlates to somebody being first in line, but it could be one more piece of information that helps you in making that initial assessment. Right. And then, of course, you're going to go to the USPTO as well. So if you go, and I'll just drop their website link into the chat, it's uspto.gov. You're going to go there and you're going to go under the trademarks tab and you're going to search TESS, which is their basic trademark search. And again, you're going to do variations on the word or phrase, because you don't want to just search that exact phrase. You want to search anything that looks like it or has a similar combination of words that would be searchable to the USPTO when they're reviewing a potential application. But all of those steps are super important at the time that you are deciding to name anything, because you can easily name something and automatically be infringing somebody else's rights without knowing it if you don't do due diligence. I got a phone call from a guy in Chicago last week who took over a business. It was a salon, took over a business in mid 2000s. Yes, they do have, thank you for that, Diana. They do have a search engine and a tutorial series that you can go through if you're super committed to this. Most people don't have the patience to go through all their tutorials. This guy had taken over a business that had changed names at some point prior to his taking ownership, right? And it's now, he's probably owned it for a handful of years. It's now 2022. He just got hit with a cease and desist from a salon who trademarked one letter different in the name, right? So very, very similar. Name of their salon, also in Chicago, has a federal trademark though, dating back to 2008, right? So this 2008 salon owner just learned about this new guy's salon, and he had no idea. They're in the same city, like literally almost the exact same named salon. He had no idea that this other salon is on the other side of Chicago under this name. Why? Because he never did a proper search. If he had searched even at the point of buying the business on the name, right, he probably or had some legal help doing that, he would have come up with this other salon that was very similar. And so this is kind of the trick with trademarks, is they really can surprise you in not a great way if you don't do your proper due diligence at the point of naming something. So it's actually a super, super important topic. So his choices now are going to be to try to fight that fight and somehow just, convince a court or convince the other party that even though it's one letter off, And, you know, they're both salons that tailor to high-end clientele, that somehow they're different enough that there won't be any consumer confusion. When the other party is already saying there has been and continues to be consumer confusion because the names are so close, right? So that seems like a, you know, a hard battle to face. And then the other alternative is rebrand, right? So he just bought this business a handful of years ago and he's already having to rebrand. And that happens all the time. Yeah, so super good question. Cindy, I hope you pop back in and watch the recording on this. All right. Anybody else? And I apologize for the poor, probably sound quality that people might be getting because of my lack of mic today. Diana.
Hi, I sent in, I don't know if you were able to see what I sent in, a question related to the payment processors, the PCI.
Oh, okay.
I just got I've had payment processors for a long while, but I had signed up for one in 2016, never used it. It was a test account. And so I just verified that they had closed the account because I don't, but it was an interesting, I thought it might be a helpful discussion to have because I know I use Square and Stripe mostly, and they do not have they don't require, because they're doing the processing of the payments as related. For people who are listening, maybe you can get a better description, but it's related to the merchant payment processing.
Yeah, I would need to go pull up your email. Let me see if it comes up, Diana, in regards to that, because I somehow did not see it, but
I sent it this morning.
Oh, got it this morning. Okay, let's see. Okay.
Because it took me a little bit to get it, to make sure that account was closed because I don't use it. And it integrates with, it's a payment processor that PayPal uses.
Oh, got it. Well, I
yeah.
don't see, I see you're saying that looking forward. Oh, can you discuss some of the PCI compliance requirements? Okay.
Yeah, it's kind of broad. And my understanding is that Stripe and Square, they actually handle that for you because they are the payment processors, right?
Right. I was gonna say mostly my clients, that's about how you protect sensitive data, right? So everything you need to know about PCI compliance in 2022. Let's just take a look at this. So the payment card industry, right, stores and transmits a whole bunch of data. So yeah, typically they're going to be the ones that have these compliance issues as the payment processor themselves. But it applies to any organization regardless of size or number, like number of transactions that are handled by that organization, that transmits, accepts, or stores cardholder data, right? So that's the question number one is, are you storing cardholder data? So for example, I'm not, right? I don't keep any credit card information, card holder information. I mean, obviously I have their name if they're in my Infusionsoft account and I have their email address, but I'm not storing their credit card information in my systems or backing that up anywhere, right? So PayPal would. PayPal is one of my payment processors. Stripe is another payment processor, right? And then I've got a separate payment processor that handles my legal clients on the Pierce Law side. So they are all going to be subject to these PCI compliance issues, right? But if you are downloading and storing that information anywhere, like potentially you might be subject to the same levels of compliance if you are keeping it somewhere in your business, right?
I did in the past. I don't do that kind of work anymore, where I do.
Okay.
I was before, like when you manually process the credit card slips, you actually had copies in the files, right?
Got it.
Yeah. But I don't do that anymore. And this was concerning because it was, PayPal is integrated with Braintree, and Braintree was calling for the annual compliance paperwork. And I was like, first of all, I don't use it.
Yeah.
Second, I thought that was very strange because, you know, Square and Stripe both, that's their gig, not mine. I don't store anything.
Yeah,
I just
right.
go, right?
Yeah, I just copied the list. The numbers didn't show up. It was 1 through 12. They're into the chat, right? This is the a site that talks about compliance and says these are the things you need to do. And it's basically like all the things that we should be doing to keep our computers and our information safe anyways, right? Using
Right.
firewalls, password protection, encryption, antivirus software, right? If we have security systems, right? Utilizing those and keeping the software updated, restricting access to cardholder data. This could apply to your list data as well, right? Not everybody that maybe supports you in your business needs access to that information, right? Assigning unique IDs associated with that data. I think that happens like as part of the encryption process, restricting the physical access, creating and monitoring access logs, testing security systems, and then creating a policy that is documented and that can be followed. So yeah, my advice to small business owners is less is more. Don't keep anything that you don't directly need. Let your third-party business partners like PayPal or Stripe or whatever do their job and maintain the backups and maintain the systems. But yeah, important to know.
Yeah, I just thought they flagged me and I thought it might be pertinent because whatever's going on right now, related, it seems to be trending.
Yeah. Do payment processors. Yeah, it'll be something to watch. I'll see what comes up under this other search. Payment gateways. I really think, yeah, so it says all businesses that store, process, or transmit payment cardholder data must be PCI compliant. And it just means that you have to have systems to protect those. Merchants, processors, acquirers, issuers, and service providers, right? If you're storing that sensitive data. So yeah, I mean, I'd have to do some additional research into that. It very much overlaps with like my training on the GDPR, like understanding data flows. What data are you keeping in your business? Where is it being kept? Who has access to it? What systems do you have in place for protecting that, right? Documenting that so that you've actually got a privacy practice that you follow. It's not just about posting a policy. It's also having practices in your business that you follow and that other people, if you've got a VA or you have other people that support you inside your business, maybe you've got a technical support team or you do, you have a marketer that comes in and access certain of your information. Totally. You're welcome, Gina.
Thanks, Heather.
Yeah. About making sure you've got your policies all up to date. Yeah, good question. All right. Well, we took everybody right up to the top of the hour. Barbara, do you have a question? I see your hand up.
I do have a quick question about derivative works. And if you register, the biggie, you have to wait for the certificate to be in hand for you to register then derivative works from that manual. Or could you just go right ahead?
That's a good question. I would think if you are confident in the ownership, right, you could go right ahead. The question, I think it becomes a sticky wicket if there are multiple owners, multiple creators in the original work, and you don't have documents showing your ownership. So yeah, I guess the quick answer is I don't know exactly, Barbara, but it is a super good question. I want to look it up now myself.
I know that there was a case in the last couple of years of someone who wanted to sue and their registration was in process, but it hadn't been completed. And so they weren't allowed to sue.
Oh yeah, I know you can't sue, right? Without a registration. This is the benefit. And it's too bad that Gina left, but maybe I can ping her. This is the benefit of having a federal level registration is that, right, to be able to enforce your rights, collect attorney's fees, do any of those things, you do have to have a registration to basically be able to do the follow-up adequately and make sure that your rights are protected. And often attorney's fees are what will keep people out of the game, right? That will prevent them from even being able to pursue their rights. And so that is the difference between saying, oh yeah, the work is mine, I own it, and being able to actually go do anything about it if somebody violates those rights.
Right.
Yeah.
Yes.
Super important.
Yeah. Thank you.
Yeah, you're welcome. Good question. All right. Anybody else?
So I had a question. I've
Mhm.
seen SM instead of TM. What does SM mean?
Yeah, SM is for a service mark versus a trademark, right? They're very similar, but a service mark protects basically a service. So if you have a specific service that you provide, that you are obtaining a mark, like a registration for, it would be called a service mark, versus a trademark that is typically for goods. Right.
So is the process similar then?
It's the exact same. Yeah, they're interchangeable phrases for basically the same outcome.
So it's still the same department that you go to. Okay.
Totally.
All right. Thank you.
Yep, absolutely.
And once you federally registered that SM, then you would have an R in the circle?
Yeah, for both the SM or the TM, which puts people on notice that you are seeking protection or claiming that phrase or word or name as proprietary, once you obtain the actual registration certificate. So this is after that 12 to 18 month process, after the 30-day window, right? Boom, it actually registers. You become the registrant in the USPTO database. That's when you're able to go put the R in the circle following your mark wherever you use it. And it is recommended that you do that, right? Because then people understand like, oh yeah, this is a mark that is owned by somebody and is registered. Yeah, great questions. All right. Anything else? We're good. All right. Well, good to see you all today. Wishing you a fabulous week. I know. Happy Monday. Glad you caught us, Diana. Good to see you, Barbara and Stephanie. Pop in anytime. All right. Bye-bye.